If you have been hesitating about submitting a green card application, today's presentation is going to fundamentally shift how you approach that choice. Because here is something that needs to be said clearly and directly from the very beginning. 2026 stands out as one of the most critical and consequential years in recent history when it comes to United States immigration. The individuals who take action now, who genuinely grasp what is at stake and make the right moves today, are the ones who will find themselves in a substantially stronger position 6 months, 1 year, and 5 years down the road. Whether you are currently living inside the United States on a temporary visa, whether you have family members here who are citizens or lawful permanent residents, whether you are living abroad and dreaming of establishing your life on American soil, 7 compelling real-world reasons are going to be laid out for you today, explaining why pursuing a green card right now in 2026 could be one of the most significant decisions you ever make for your personal future. Stay engaged through every part of this presentation because each of these reasons carries genuine weight. And at the conclusion, practical steps will be outlined that you can begin taking today to move your case forward. This is not legal advice, and that point will be addressed directly. But this is some of the most valuable and timely information available on this subject right now. So let us begin with the broader context, because understanding the full picture is absolutely essential here. The United States immigration system in 2026 is functioning under conditions of meaningful and ongoing transformation. USCIS, which stands for United States Citizenship and Immigration Services, has rolled out a series of updated policies. Executive orders have fundamentally redirected enforcement priorities, and the overall processing environment looks considerably different than it did even 18 months ago. Official reporting from USCIS and the Department of Homeland Security makes it clear that vetting procedures and security screening have been substantially broadened, particularly for nationals of countries currently classified as high risk under active executive orders. And while those policy changes have introduced genuine obstacles for certain applicant groups, they have simultaneously created an important reality that many immigrants who are currently in solid legal standing are not fully recognizing. If you are eligible right now to file for a green card, postponing that decision may actually cost you far more than moving forward. Let me walk through exactly what that means, reason by reason. The first reason is this. The opportunity window for filing may be getting smaller, and priority dates are actively shifting. If you monitor the monthly Visa Bulletin that is published by the United States Department of State, you already understand that immigrant visa availability is tracked through what are called priority dates, which essentially represent your position in the queue. What the April 2026 Visa Bulletin makes clear is that dates for filing and final action dates have been advancing across several categories, partly because nationals from certain countries are now unable to use visa numbers as a result of proclamation-based entry restrictions. That may sound complicated, but here is what it means in straightforward terms. Visa numbers that would previously have been allocated to applicants from restricted countries are now becoming accessible to others. If your priority date has reached current status or is approaching it, this could be your critical moment. And if you choose to wait, those dates can retrogress. They can move in the opposite direction as circumstances continue to evolve. The Visa Bulletin is published every month at travel.state.gov, and checking your current standing there should be among the very first actions you take after finishing this video. The second reason involves a significant policy change that USCIS formally announced in connection with the May 2026 Visa Bulletin. Beginning in May, employment-based adjustment of status applications will only be accepted when the applicant's priority date is current, under the final action dates chart, not under the more permissive dates for filing chart that had been accessible for the preceding 18 months. Industry observers and immigration legal professionals have highlighted that this change will immediately and substantially narrow the pool of individuals who are eligible to file. And those who had been preparing adjustment of status application packages based on March or April filing date, eligibility may now be required to revisit their entire strategy. What does this mean for your situation specifically? It means that the rules governing this process are evolving rapidly, sometimes with very limited advance notice, and those who are already positioned to file now before further restrictions come into effect hold a genuine and time-sensitive advantage. If your employer has been managing your green card sponsorship, reach out to your human resources team and your designated immigration counsel today. Do not postpone this until summer arrives. The filing opportunity that currently exists may not be there when next month's bulletin is released. The third reason is one that resonates deeply for families navigating this process, and it centers on job security and liberation from employer dependence. This is one of the most genuinely transformative advantages of holding a green card, and it simply does not receive the attention it deserves in most conversations about immigration. If you are currently authorized to work in the United States through an H-1B visa, an L-1 visa, an O-1, or virtually any other category of temporary non-immigrant work authorization, your legal right to remain in this country is fundamentally tied to the decisions of your employer. If your company reduces its workforce, if you decide you want to pursue a different opportunity, if you want to take the entrepreneurial leap and launch your own business, every one of those scenarios carries real immigration risk when your status depends on an employer's continued sponsorship. A green card changes all of that in a profound way. As a lawful permanent resident, you have the right to work for any employer across any industry without requiring anyone's sponsorship. You can pivot your career entirely. You can take a calculated risk on an early-stage startup. You can enter any salary negotiation from a position of genuine strength because your ability to remain in the United States is no longer contingent on what your employer decides to do. In 2026, as the job market continues to undergo rapid transformation across technology, healthcare, finance, and countless other sectors, that degree of professional freedom is not simply valuable. It is genuinely irreplaceable. The fourth reason centers on creating lasting stability for the people you love most. Consider for a moment what it truly means for your spouse, for your children, for the family members who depend on you, to have permanent legal status established in the United States. Once you hold a green card, your spouse may qualify for derivative permanent resident status. Your unmarried children under the age of 21 can frequently be included within your application. And once you yourself eventually pursue naturalization as a United States citizen, which most green card holders become eligible for after 5 years of lawful permanent residence, or 3 years if you are married to a U.S. citizen, you gain the legal capacity to sponsor additional family members, including your parents and siblings. The difference between what a lawful permanent resident can do for family members and what a full citizen can do is meaningful and substantial, both in terms of which relatives you can petition for and the speed with which they can join you. But every part of that journey begins with the same foundational step, which is the green card itself. Right now in 2026, with the immigration landscape undergoing significant transformation, having your family status secured through lawful permanent residence provides a degree of stability and protection that absolutely no temporary visa category can come close to replicating. The fifth reason is one that genuinely catches many people off guard, particularly those who have been residing in the country for years on work or student visas. It involves access to federal benefits, financial aid programs, and long-term financial planning tools that become available upon securing permanent residence. Green card holders may qualify for a range of federal and state-level programs and benefits that are entirely unavailable to most individuals holding temporary visa status. That includes eligibility for federal student financial aid, which can make an extraordinary difference for families with children who are approaching college age. It includes eventual access to Medicare after meeting the applicable eligibility requirements. It includes the ability to qualify for government-backed mortgage programs, which means that the dream of home ownership becomes a far more realistic and attainable goal. And it means that the substantial contributions you have been making to the Social Security system through every paycheck you have received are being credited toward benefits that you can actually access and collect if you maintain your permanent resident status through your working years and into retirement. These are concrete, financially life-changing advantages, and every month you delay locking in your permanent resident status is another month during which you are deferring access to all of them. The sixth reason speaks directly to the realities of the current environment, and it deserves to be framed thoughtfully and responsibly, because the goal is never to generate unnecessary anxiety, but to present an honest and complete picture of the landscape you are navigating. The current administration has made expanded enforcement intensified vetting procedures, and heightened scrutiny at ports of entry a clear and stated priority, particularly for non-immigrant visa holders and even for returning lawful permanent residents who have spent extended periods abroad. Credible immigration legal practitioners writing and advising in 2026 have noted that CBP officers are currently operating under expanded vetting directives that instruct heightened scrutiny toward returning residents, particularly those from countries identified under active executive orders. If you are currently a non-immigrant visa holder, or if you are maintaining a temporary immigration status, your legal position is more vulnerable than that of someone who has already secured permanent residency. A green card does not render you completely immune to immigration enforcement. Lawful permanent residents carry both rights and responsibilities, and maintaining status carefully is essential. However, permanent residency provides a significantly more robust legal foundation than virtually any temporary status currently available. The earlier you begin the process of establishing that foundation, the better prepared you will be if the broader landscape experiences further shifts. The seventh reason has been saved for last because it is arguably the most powerful of everything covered in this video, and that is the pathway toward United States citizenship. If your ultimate goal is to fully belong in this country, if you want to exercise your right to vote, if you want the most comprehensive legal protections the United States government can extend, if you want the freedom of a U.S. passport and everything that comes with it in terms of international travel, if you want the ability to sponsor your parents directly, then full citizenship is your ultimate destination. And that destination begins with a green card. The vast majority of green card holders become eligible to apply for naturalization after 5 years as a lawful permanent resident. Spouses of United States citizens may reach eligibility after just 3 years. But here is the critical point that deserves your full attention. That 5-year clock does not begin running until the moment you receive your green card. Every month you choose to delay your application is another month you are pushing your potential citizenship eligibility further into the future. And as immigration attorneys and practitioners across the country have observed in 2026, many long-term permanent residents are choosing to pursue naturalization sooner rather than later, recognizing that citizenship carries the strongest legal protections of any immigration status, including full protection from deportation under most circumstances and the complete elimination of any risk of status abandonment due to extended international travel. At this point, transparency is owed about the landscape you are walking into, because a complete and honest picture requires acknowledging not just the reasons to act, but also the realities that need to be navigated carefully. Pursuing a green card in 2026 is not a simple or straightforward undertaking. Processing times vary considerably depending on application category and individual circumstances. The median processing time for certain application types has increased substantially during the first half of this year. USCIS has implemented adjudication holds for applicants from countries that have been designated as high risk under presidential proclamations. These holds affect multiple application types and mean that even cases that are otherwise fully approvable may not receive a final decision for an extended period, depending on the applicant's background and country of origin. USCIS has been transparent about these policies through official announcements published on uscis.gov. And if you or someone close to you is from a country that may fall under these designations, consulting with a qualified immigration attorney before submitting any filing is absolutely essential to understanding how current policies apply to your specific circumstances. What also deserves to be said clearly is this: the fact that this process has become more complex and that the environment presents genuine challenges does not mean you should disengage from it. It means you should engage with it deliberately, with accurate and current information, and ideally with the guidance of a qualified professional. The individuals who will be in the strongest position 1 year from today are those who are gathering information right now, consulting official government sources right now, and taking purposeful action right now. So let us move into the practical steps you can begin taking immediately. The first action is to visit uscis.gov and bookmark that page. That website is your definitive source of accurate information for every question related to application forms, filing fees, current processing times, and policy updates. Do not rely on social media posts or secondhand accounts from friends or community members. Go directly to USCIS.gov every time you need information. The second action is to review the Visa Bulletin. It is published monthly by the United States Department of State at travel.state.gov. Locate the preference category that applies to your situation, whether that is family-based, employment-based, or the diversity visa program, and determine whether your priority date is currently current or approaching current status. The third step is to begin assembling your supporting documents right now, even if you are not yet at the point of filing. Your birth certificate, your valid passport, your marriage certificate if applicable, your most recent tax returns, your employment history and records. Start organizing all of these materials now. Even if your priority date has not yet become current, having your documentation fully prepared means you can respond and move forward immediately when the right moment arrives. Fourth, if you believe you may currently be eligible to file, or if you have questions about how current policies apply to your personal circumstances, reach out to a qualified immigration attorney or a Board of Immigration Appeals accredited representative. This is genuinely not a process you want to navigate without professional guidance, if that option is available to you, particularly in the current environment of 2026. A qualified professional can carefully review your documents, evaluate your eligibility, identify any potential complications before they become serious problems, and help you present the strongest possible application. A brief word is also warranted about the financial dimension of this process. USCIS implemented an updated fee schedule in January of 2026, and filing fees for adjustment of status applications, including the biometrics component, now total $25. That represents a meaningful financial commitment, and that reality is fully acknowledged. But weigh that cost honestly against the long-term value of everything discussed today. The professional freedom, the family stability, the access to benefits and financial programs, the pathway to full citizenship. This represents one of the most consequential investments you can make in your own future and the future of your family. And the cost of continued waiting, including the opportunities that pass by and the vulnerability that persists, is frequently far greater than any filing fee. Before bringing this to a close, an important reminder is in order, as it always should be when discussing this topic. United States immigration policy can and does change. Sometimes those changes happen quickly and with little advance warning. Everything presented in this video is based on information that was current and accurate as of late April 2026, verified against official sources including USCIS, the Department of Homeland Security, the United States Department of State Visa Bulletin, and reporting from established outlets operating within the immigration legal field. But circumstances can shift after the date of this recording. What holds true today may look different in the weeks and months ahead. That is precisely why checking the most current available information directly on uscis.gov and travel.state.gov is always encouraged, and why consulting with a qualified immigration attorney for guidance that is tailored to your personal situation is always the right approach. Nothing contained in this video constitutes legal advice. It is information, honest and carefully researched information, but your individual circumstances carry enormous weight in any immigration matter, and a qualified professional is the appropriate person to evaluate those circumstances alongside you. So let us bring everything together clearly and concisely, because leaving with clarity and a sense of direction is the goal. Priority dates are shifting, and the window for filing may be narrowing, so check the Visa Bulletin without delay. USCIS is transitioning to final action dates for employment-based filings beginning in May 2026, so if you fall into that category, there is no time to waste. A green card liberates you from employer dependence and empowers you to build your professional life entirely on your own terms. Permanent residency creates meaningful stability for your spouse, your children, and your broader family. As a lawful permanent resident, you gain access to federal benefits, financial aid opportunities, and long-term financial planning tools that remain unavailable to most visa holders. In today's enforcement environment, permanent residency provides a significantly stronger legal foundation than any temporary status. And a green card sets the clock in motion on your journey toward full United States citizenship. And that clock begins only when you take the step of applying. This is what this channel is fundamentally about: delivering the information you genuinely need, presented with honesty and clarity and without manufactured alarm, so that you are equipped to make the best possible decisions for yourself and for the people who matter most to you. If this video has been valuable to you, please take a moment to give it a like and pass it along to someone in your circle who may be weighing this same decision. Every share extends this information to more people who need it. And if you have not yet subscribed, please do so right now and activate the notification bell so that important updates reach you as soon as they are available. Every significant development relevant to your immigration journey is covered here, from Visa Bulletin changes to USCIS policy updates to practical on-the-ground guidance for families working through the system in real time. The description of this video contains links to official USCIS and Department of State resources, along with information about how to locate qualified immigration legal assistance in your area. Thank you sincerely for investing your time here today. Your journey matters, and you are not navigating it alone. Stay informed, stay prepared, and we will see you in the next one.